So, hello, ma'am. How are you?
Hello, I'm very well, thank you so much.
Yes. So, we're supposed to be continuing again our topic mediation, and today's our topic is the types of cases that we can mediate. So,
Yes.
starting with the first case, what is the most preferable case that can be mediated, and then we can proceed with other types of cases.
All right. So, to very simply answer the question of what are cases that are best suited for mediation, so basically, uh, all types of cases and every case is actually suitable for mediation except those which are specifically barred by the law. So, generally, as common practice in most parts of the world, and not all parts of the world, but most parts of the world, matters that are criminal in nature or criminal cases are not subject to mediation. The reason for this primarily can be associated with the fact that mediation is a dispute resolution mechanism to resolve conflict between individuals. That are criminal in nature are not considered to be offenses against an individual but against society at large. And therefore, as a single individual, you are not allowed or you are not considered, to be able to take that decision as to what should be the conclusion in that case. So that's primarily the reason why criminal cases per se are excluded from the purview of mediation. However, if we look at what Section 6 of the mediation law says, it does talk about cases which can be mediated or which are actually not suitable for mediation. And it mentions that cases which are basically mentioned in Schedule 1 are cases which are not suitable for mediation. So, except the cases that you find in Schedule 1 of the Mediation Act, all other cases are suitable for mediation. There is a long list of cases that are provided in Schedule 1, but yes, so basically, that is how we can have a general understanding that whenever matters relate to individual disputes, they are more suitable to mediation as compared to matters where you're involved in, say, for example, establishing a right. So if you want to go ahead and exercise or you are trying to execute a fundamental right, now that is something that is difficult to mediate or is something that is out of the purview of mediation, because that right is not against an individual. That right is against the world in general. So when you have rights that are in rem or that are rights per se, and you're trying to protect those as per the law, those are the cases where ideally mediations are not considered to be suitable. For example, generally if you're say looking at a title dispute, but the title dispute is against the government, mediation in those cases can is something that is not permissible, because eventually that decision is going to affect public at large. It's not only about individuals. Whereas if you're talking of title deeds between two individual disputing parties or even two entities for that matter, it's considered to be much more private in nature. So even if you reach a settlement which is suitable to both parties, it doesn't affect anyone else except the parties who are directly involved. Whereas if it is, say, a title that leads to a government title, it's not only between the individual parties who are in court or who are in dispute, and therefore is considered to be unsuitable for mediation, because that decision which parties will take or the individuals sitting there will take, depending on their own convenience or what they feel is right in that case for them, may not be right for everyone else or may not be suitable for everyone else. So in those cases, mediation is best avoided. In fact, it is something that Schedule 1 talks about as well. So those are cases which we cannot mediate. But yes, if there are individual disputes between parties, and for most type of disputes, mediation is absolutely not only suitable but is a wonderful option.
Okay, so what the first case that we can discuss, of course, for mediation purpose?
So, for example, now one of the major areas where mediation has been used is matrimonial cases. So, when we are looking at matrimonial cases, for example, mediation is definitely something that is available. However, in a lot of matrimonial cases, and I'm particularly looking at, when cases are filed for divorce, they're not only civil cases that get filed. Sometimes there is a criminal case that gets filed along, like, for example, a 498A. So, when you have multiple cases clubbed in this sense. So you could ask me a question saying that because these are criminal in nature, so they're out of the purview of mediation, then what happens in those cases? Now, because these are very sensitive issues, if the matters or if the charges that have been filed against individuals, and this is something that is spoken of in the section itself. So if we refer to section 6 itself, the law does talk about cases which are technically not available for mediation because they come under criminal proceedings. However, if they are compoundable offenses, and if the court in its wisdom decides that these cases are probably fit for mediation to be attempted at, and this particularly works also in matrimonial cases, the courts themselves make a reference or refer these matters for mediation. So it happens through the courts in cases which, though technically are considered to be criminal proceedings, but because they come within the purview of what we call as compoundable offenses, which are generally considered to be slightly milder nature of offenses, the courts themselves, in the wisdom of the court, if the court feels that these are matters which would probably be best suited for mediation or could be best settled through mediation, the courts do refer these matters for mediation, and that includes a majority of cases, including matrimonial disputes. The difference here, and this is important for us to understand, is that in a regular mediation in which private parties enter, even if it is a court-referred mediation, but is not something that involves criminal proceedings, in those matters, if the parties arrive at a settlement, the settlement, once signed by the parties and the mediator, is equivalent to an award or to a decree or an order of the court. So it has that value. Whereas in cases where you do have matters that involve some kind of a criminal offense, even if it is compoundable, even if it may have been referred for mediation by the court, and if the parties arrive at a settlement, it does not directly get converted into or get the status and the value of an order of the court or a decree of the court. It does go back to the court, and the court actually goes through the settlement terms to see whether it is appropriate or not, so that there is no sort of overriding the basic principles or the basic components that the law has laid down. So that is essentially the difference when we look at these certain proceedings which come within the domain of what you call as compoundable offenses. So the court does keep a little bit of check. Of course, if there doesn't seem to be any kind of gross error in the settlement terms, it does get passed through the court process. So that's really not the issue, but it's just like an extra, like an extra checkpoint where the court ensures that there is no illegality that gets passed through because it's gone in for mediation. So yes, in that sense, some of these matters which technically come under the concept of criminal proceedings are covered under mediation, but it's only under the guidance of the courts.
Okay, so as you mentioned that it is feasible with the compoundable kind of something like offense. There is in core criminal cases, of course it is related to matrimonial. Core means that is independently related to criminal matters. So if it is compoundable in nature, even for that, not exactly mediation, but I believe in 2005 or somewhere 6, there was an amendment and a concept of plea bargaining inserted. And that is, of course, we can't call it mediation, but yes, that is something that both the parties can come up and the offender can accept his guilt or her guilt and can, of course, in front of magistrate only, and then can things go like that. So it reduces the trial period or something like that and come on conclusion, and against that the offender gets something like the lesser amount of punishment, whatever already defined under the IPC.
So, when we look at the concept of plea bargaining, it is very interesting, but is very different from mediation.
Very different, of course.
Because in mediations and the kind of agreements that are drawn in mediations, you are not establishing anyone's guilt.
That is
so you are just coming to what is the best possible solution to handle that situation in the future, and whatever the decisions may be. Now, when you're looking at matrimonial issues, because we're on this topic, you are not necessarily looking at somebody going to jail, because that's not something that is in the purview of mediation. It's just parties agreeing as to what they want to do and how they want to sort of settle this dispute without really having too much of bad blood, so that you are able to be at peace. That's ideally how it is. Now, when we look at plea bargaining as a concept, that's something that you're really almost having a little sort of an agreement with the state, wherein you are saying that I'm agreeing to what my crime is. I'm saving you the time of the many years of trial that we will go through, but in the bargain, I'm agreeing to a smaller punishment.
Yes, as the name suggests.
Yes, so that is how it actually technically works. Yes, it's also a mechanism of trying to have the courts resolve these matters or complete cases at a faster pace. However, of course, in terms of when you're comparing it to mediation, the process is
entirely different.
Very, very different.
Entirely different. But it has some flavor. You can say some flavor, because it is not possible with the non-compoundable kind of offenses, only for petty crimes. Yes. Where it can be managed, the things. So that is, of course, both parties have the opportunity. Even the second party, if ready to withdraw the case, then of course matter resolved there only by giving some fine, on only monetary kind of fine, not the punishment or imprisonment at all. That can be excused if it is mere 15 days or 30 days kind of. So that can be excused, but of course that is the concept there and entirely different from the mediation. But yes, it has some flavor. Both parties have the freedom to decide themselves in front of magistrate only.
Yes,
as in mediation people do.
Yes, so basically, I think the only similarity that is the party one, of course, voluntarily participates in plea bargaining. You can't force somebody to do that, and they take their own decisions.
Yes, that's
looking at what is most favorable for them. So that is something that you can say is a point of similarity between the two. But yes, otherwise, in terms of the procedures, because in plea bargaining, generally the second party or the complainant is not as involved, and it's a slightly different process itself. It's where the state is primarily involved. But yes, if you're looking for a similarity, yes, the person who's the offender or the person who's been accused, not offender, actually, that's not the correct term. The
Accused
accused
and
person
plaintiff.
has that option to be able to choose what is the best suitable option for them. So yes, so the exercise of that discretion is something that is common, that you will have in mediation as well as possibly in plea bargaining. But yes, I'm just going to reiterate, otherwise processes
Yeah,
vary.
yeah, that's why I use the term flavor. It has the flavor only, but not
Yes.
the core content. Okay, anyway, so what is the next topic? I mean, next type of case that we can take for mediation?
So basically, like I said, except the cases that are actually barred uh, by the law uh, described in Schedule 1, all other cases actually can be taken up comfortably for mediation. Now, if I were to give you examples, we've already spoken of matrimonial matters. They are primarily what can be taken up very comfortably. Property disputes are another very a suitable option for mediation. In fact, instead of spending so much time, energy in courts, waiting for that dispute to be settled after many, many, many years, sometimes we've seen that it takes generations. So the dispute is between, a set of, say, for example, brothers, and then it's their grandchildren who are finally getting the judgments. So to avoid that, because what mediation does in particularly property or family disputes which are other than matrimonial as well, it not only helps you to resolve the dispute at hand, which could be the land, which could be the property, which could be an estate, which could be a will, any of the main obvious issues, but it also helps because it establishes a line of communication to be able to clear out other differences that eventually have led to the dispute. So when we look, for example, where individuals are concerned, and this could be applicable in a whole lot of type of cases, whether you look at, even for that matter, matrimonial, whether you're actually looking at property disputes, whether you're looking at family disputes, partnership disputes, business disputes, even if they are commercial in nature, sometimes. I've spoken of this in an earlier session as well. When we're looking at dispute, broadly it appears to be something. But when you actually explore the interests, why does a party appear to want something? When you try to understand that, at a very deep level, you realize that the actual interest is something completely different. Something may have hurt an individual, what another person said or what another person did, and then that kind of builds on and on and on, and eventually you find a ground and you create a dispute. So when you enter into mediation, in actually any type of matter, but particularly in family disputes, in property disputes, you will realize that it is not only the dispute that gets resolved, but you're actually targeting the underlying conflict that exists. Because the moment that conflict gets resolved, the dispute automatically resolves itself. So that is actually the beauty of the process of mediation, because it takes a little bit of time and effort, and of course intention on part of the parties as well, as you keep exploring. And they are not always easy conversations. These are difficult conversations. Our egos sometimes come into the way and play their role. But once you overcome all of that, and you really reach the deep-rooted interest level of the dispute, it kind of almost untangles itself. Sometimes just understanding where it has come from can help resolve those disputes. And then you realize that eventually what you're fighting for, it doesn't really make as much sense. Like, for example, many times you find this, that children are negotiating or fighting over property of a deceased parent. For an external person who's viewing the will, it looks absolutely fair. But the dispute is going on, and if you go to court also, that, I mean, obviously, because the courts are looking at the evidence and what is available, and but when you go into the conversations that you're having with the parties, then comes up all the the what happened, why did the parents support this person in this thing and did not support me in something. So those smaller issues come up, and eventually you realize that that is really the crux of why this is eventually happening. And the moment you resolve that, not only are you resolving this property dispute, but you're also creating better relations between the parties. And that is really the beauty of this process. I keep saying this, but that is really a fact. And that's one of the reasons why when parties enter into mediation, when they come out there, even if the core issue maybe is not resolved, they come out with that sense of satisfaction, because it's not always that you are going to have a settlement, but you come back with something, that relationship becoming a little better than what it was earlier. And sometimes that is also good enough. So that is another type of dispute that can be resolved. Business, very classical. Now, when we speak of these property dispute, most of them, we are talking about those underlying interests. Not that in business relations you don't have it. In most business relations also you will have it. But another advantage for specific business related issues is when you are in business. One, you don't want your matters to be
disclosed.
Yes, you're flying around in the courts and it being all over the media. That's definitely not something that you're interested in, because it hampers everybody. When you're in the business because you want to work with each other.
And that also affects the credibility of the companies or something like that.
Absolutely. There is a pure business dispute. One, you don't want the matter to be exploited in the court, because it's going to be in the media. It's not good for anyone. Two, primarily when you are in a business and you have somebody that you are in a working relationship with, it does help to resolve that, because eventually both of you are there to be able to progress in your own work, in your own world of business, or whatever it is that you're doing. So eventually tomorrow you need so I'll give you a simple example. I'll say there is a purchase and supply. Now, you have been purchasing something from a particular vendor for a considerable number of years. Suddenly, a dispute arises. It could be a payment issue. It could, because of some issues, you are unable to make the payment. Dispute arises, so they file a case. Now, you take this dispute into mediation. What mediation will try and understand, or what you will understand in through the process, is why has that not happened? Was there a problem with the supply? With the material? Was there an error in terms of the quality or something of that sort? Quantity, was it not given on time? Or why was the amount not paid? Was there some kind of other problems? Because do the parties have an intention to pay? Can an arrangement be worked out? Now you discuss all of this. If you do come to a conclusion, two things happen. One, you don't have bad blood between the disputing parties. If they don't want to work with one another, that is also fine. They can just both move on. In the event that recovery can be made, or that is how it is resolved, that can go on. That's a plus for both. If after resolving this, parties want to continue working with one another, and there are so many number of cases that I have seen wherein there's something that is a small issue that comes up, and parties eventually want to work with one another, because that is how you're going to continue in business. Because if you're going to have a problem with one vendor, there's no guarantee that you're not going to have a problem with another vendor. These are business related issues. So once you resolve that, you are actually in a position to be able to probably discuss these points that have come up in the first case and put them down on paper before you actually enter into your next agreement. So it makes that relationship much easier. So absolutely, if you're looking at business disputes, it is actually one of the best possible ways to be able to settle your disputes, because that's one of those relationships wherein continued relationships are very important. So that is another important aspect. Apart from that, even employment disputes. Now, when we look at workspaces, many a times you have disputes. Now, just like in classical business examples we have discussed, when you have workspaces, people need to, or who are as working as employees, and the ones who are the employers, they are both in need of one another. So when disputes arise, to sit across a table and to discuss what is the possible solution is possibly one of the best things you can do. Yes, having said that, not all kind of employment disputes may be suitable for mediation, because one of the clauses that are incorporated under the first schedule, and sometimes there are laws that prescribe procedures. So if you have the labor codes, there is a specific procedure that is already established, which is primarily setting up their own courts. There are arbitrations that are provided for. There are some kind of conciliatory methods that are also prescribed under the law. So in those specific cases, you will actually follow that what the statute prescribes. So it is always the statutory provisions having more weightage than the general provisions, and mediation law or mediation as a practice is a general provision. But in employment, if they are not something that is covered under any of the codes, and no specific aspect has been provided, no specific relief mechanism has already been provided, then yes, disputes can be resolved through mediation. But otherwise, if laws do provide, the mechanisms provided are more or less on similar lines, because they too talk about how you can really sit across the table and negotiate and try to keep those relations. I mean, the erstwhile Industrial Relations Act primarily focused entirely on that. But yes, even when you're looking at cases that are not necessarily covered within those legislations, for employment related disputes, unless specifically barred by a particular law, because of the availability of another remedy, are definitely available to be discussed through mediation. So that is also something that is very interesting. Then you also have your classic landlord tenant disputes. You have consumer complaints, which of course can be discussed through mediations, provided of course both parties agree to have that, and that is a viable option. In that case, those are all cases which are available and subject matter of mediations. So basically, except the matters that are barred by the law, everything else can be
Mediated.
Yes.
Okay, so, well, going a little bit back regarding the employment dispute, as you mentioned, there is a specific law and tribunal for that,
Yes.
for labor law.
Yes.
But that is, of course, there are a lot of things that can be, if the disputes regarding the employer and employees, not employee, rather employees.
Yes.
Right?
Yes.
So there are a lot of things. Then okay, fine. The common interest involved. Then of course mediation could be one of the options. But people prefer higher degree of kind of thing that can punish someone with this intention.
So the point here is not that mediation is at a lower degree than any other mechanism. I wouldn't necessarily agree to that, because like we've discussed the process, it's not really the process that's so much of an issue, but sometimes the legislation itself is providing a mechanism. Now, if a mechanism is already put in place, and that's the only mechanism that you can use, then obviously it becomes a bar on using any other mechanism. So that is the reason why you will choose. And like I said, in most industrial dispute cases or most employment related cases where you do have these provisions under the law, they are more or less lined on similar grounds. So you will have forums that are set up, whether they are grievance redressal committees or any other forums that are set up, including the labor courts that are set up. They will all almost eventually use one or the other principles that mediation also uses. It may not be called the mediation, it may not move directly in that process, but they do try to use processes which allow parties to maintain their relations, because eventually that is also something that is very, very
resolving the
important.
dispute only.
So when you're in that kind of employment kind of dispute, what is very important is to maintain that relationship. But at the same time, when you say maintain relationship, if there are rights of people that are getting violated, then those need to be looked at as well. So the only point I'm trying to make here is not that mediation is actually not suitable. If you ask me, I would say mediation is suitable to actually resolve all kind of disputes. Having said that, because we already have a law in place at the moment which may not allow those matters to be taken up for mediation, because they are strictly providing for a mechanism, and that is the only mechanism that is available under the law, in that case it becomes a bar to mediation. Not because it is better or lesser, but that is how the legislature has viewed it and prescribed that as a procedure for resolution of those disputes.
But what I believe in that case, if it is the larger interests are involved.
Yes.
If it is a single person, means his or her interest involved, then of course it can be mediated. And wherever matter of the higher degree or difference in that is something like, if we talk about the alternative dispute resolution, means whatever the modes of ADR, whatever it is, arbitration, mediation, conciliation, or there are other as well.
Yes.
In all types, you will see there are thin line differences. It's not something like a big difference as we can see perceptively or substantially, isn't it? So that is something that differentiate between ADR and litigation. That's it. After that, it's only thin line difference and mediation. What I think mediation is on top of that, because it takes care of every parties. That is the beauty of this.
Yes, so you're very right when you say that when you're looking at it, when the interests of more number of people are involved, mediation may not be the best option unless you're able to get everyone on board. Because you can't be taking a decision for somebody else. I mean, in fact, when we look at even matrimonial disputes for that matter, and I'm going to bring the topic back to that, ideally any dispute which involves a third party right, unless the third party is involved, cannot be mediated. So two people can't sit together, decide, discuss, negotiate, and decide the future of some third person. So if their rights are getting affected, it is not suitable for mediation unless they are involved in the mediation themselves. So an exception to this becomes, in matrimonial cases, custody of children, because eventually parents are discussing and the child is going to really bear the brunt of the decision. But in those cases, of course, because parents otherwise also are guardians of the child and would be taking those decisions, are allowed to do that. But otherwise, third party decisions or third parties' rights being determined by others in mediation is something that is not permissible. So when you say, when it is the larger interest, that it just extends that same point a little more. So when you are looking at or discussing the interest of a larger section of society, so when we say government titles, when we say wherever the government is involved, when we say say you have a dispute with any kind of regulatory authority, it is not an individual dispute. It is primarily a dispute, and the resolution to that dispute will affect a lot of people. So in that case, those cases are not best suited for mediation, primarily because not all parties can be brought on.
Right. So again, going back to employment dispute, because one aspect we discussed, the second aspect, it's when it is individual interest getting affected, or basically in a big firm or in corporate basically, where they don't want to let such kind of take the example of sexual harassment case. If something happened in a corporate or in a company, there of course company doesn't want to disclose it or let it go out, make it a news. So they try, because there is another mandate that if a firm is there with certain number of employees, then they have the such kind of rules for sexual harassment or kind of things, and they need to display on the board and the things, and they primarily need to resolve themselves. So if such kind of disputes, sexual harassment is one of them, so how mediation can be justified for that kind of particular dispute?
All right. So now, when we look at, I'm going to just address the sexual harassment at workplace related disputes. Now, when we look at this particular form of dispute,
because this is criminal in nature as well.
It was introduced in 2013 itself. There was a provision in the law which spoke about conciliation. That in the event the complainant woman was willing to explore the possibility of a conciliation, that is something that could be conducted. However, that has since now been repealed and it is no longer available. And conciliation is a process, even at the time when it was actually introduced, when the law came into force for the first time, there was a lot of debate and discussion over this. We know that how are you going to actually be able to mediate or discuss or conciliate this matter? So eventually that provision has been struck off, and today that is not something that is available. However, there are, when we look at how these matters get resolved, you're looking for solutions, but you're not necessarily mediating it, because they're considering it to be a very severe offense. Even if you're not talking about some kind of a physical assault, even then it's serious in nature and it is not something that is available or subject matter of mediation. But you can have a lot of other kind of disputes that arise, and even if you're not going in for formal mediation, for example, so there are say some kind of differences that arise. Now, when we speak of mediation, yes, we are speaking of the law and cases, and otherwise you would go to court. But even regularly at workspaces, if the idea is to really create safer and workspaces that help everyone to be able to bring out the best in them, then to have dispute resolution desks where you have people who are trained. Now, what is a mediator? It's not only a degree. It's basically people who are trained in how you can resolve these disputes. So when you have somebody who's an independent, neutral individual who's not part of the organization, so who doesn't belong to the HR department, but who's actually sitting across the table, having disputing parties, no matter what the dispute is, and just asking or helping them communicate with one another to be able to try and find a possible resolution, understanding why it is happening in the first place, and then what is it that parties can do to be able to try and resolve that dispute. So even for that matter, something as simple as that, it doesn't necessarily have to be an industrial dispute between a worker and but even just individual level disputes can be resolved through this mechanism.
Of course, it could be salary
issue. Matters that you wouldn't consider to be serious enough to be taken to court can be resolved between individuals at that very nascent stage, and you never will reach a time where you need to resolve disputes. In fact, workspace disputes is a very, very big issue that a lot of organizations are facing, and to just have these mechanisms of having more open communication between parties to understand their issues with one another, whatever it is, whatever those issues, they could be something trivial, or they could be something extremely serious. But when you are open to having that culture of discussion, and if parties are not able to do that on their own, they can very well sit across themselves over a cup of coffee and try to resolve their dispute. But sometimes it's not that easy for the parties, because each one is only looking at probably their viewpoint, and sometimes you are not able to understand the viewpoint of another. What the mediator actually does as the third party in that conversation is just being able to help the parties understand another's perspective. That is basically what you're trying to do. So even in workspaces at that level, definitely it's something that can be worked out, and can the process of mediation, I think I probably must have said this earlier also, is not only for your formal disputes which you are going to have before court. It can actually be used at every level. And that's where, when you look at workspaces, definitely people who are trained in how you actually diffuse tension, how you get people to talk to one another, is something that can be of great advantage to any organization.
Yes, and this is this is really nice topic, workplace dispute, because these days these kind of things is really rising up.
Yes, it's a very, very important area of work, and I think it needs a little more attention than it's getting at the moment.
And exclusive session.
Yes, absolutely.
So I think for the topic types of the cases that we can mediate, that is, of course, we concluded that with this question. So we should end this session today here only, and then in next topic we will take some specific case, right? So thank you so much for the time and having such a nice discussion and so informative. So thank you so much.